What if I told you that 4 conversations this year could completely transform how you practice law in 2026? After 46 years in the trenches as a trial lawyer, managing partner, and now a coach to attorneys nationwide, I've learned something that most lawyers never figure out. The biggest threat to your career is not your caseload, your competition, your demanding clients, or even that difficult opposing counsel. It's what's happening between your own ears. Here's a startling reality. 28% of lawyers experience depression. The legal profession has one of the highest rates of burnout, substance abuse, and yes, even suicide of any profession. And yet, the solutions are not complicated. They're just not taught in law school. Today, I'm giving you a gift. I'm pulling back the curtain on the 4 most powerful efforts from the Free Lawyer podcast in 2025. The ones that generated the most response, the most transformation, and the most I needed to hear this message in my inbox. So, Happy New Year. Welcome to 2026. And by the end of this episode, you will have a complete roadmap for staying present when your mind wants to race to disaster, turning your worst professional defeats into your greatest strengths, using AI to free yourself from administrative burden without compromising ethics or quality, and mastering the psychology of persuasion that wins cases and clients. This is not theory. This is what worked for lawyers just like you in 2025. So let's dive in. Welcome to the Free Lawyer Podcast. I'm your host, Gary Miles. So I spent over 4 decades practicing law, including 30 years managing partner of a preeminent litigation firm in Maryland. I've tried cases in federal court with millions at stake. I've won cases everyone thought were impossible. And yes, I've lost cases everyone thought were guaranteed. Now I host the Free Lawyer Podcast with 2 episodes every week, and I coach attorneys through my Free Lawyer framework to help them practice law with purpose and to live their lives with freedom. One of my coaching clients recently told me, Gary, working with you has changed everything. I feel like I finally own my own practice instead of my practice owning me. And that's what this work is about. And that's what today's episode delivers. If any of what I shared today resonates with you and you want to go deeper, I offer a complimentary coaching call. The link is in the description. No pitch, no pressure, just a conversation about where you are and where you want to be. Now let's get into the 4 lessons that define 2025 for free lawyer listeners. The first is about the power of presence, and this was episode 285 this year.
Years ago, I remember being in a critical client meeting when something jolting happened. My client asked me a question, and I realized I completely missed the last 5 minutes of our conversation. My mind had been everywhere except where it needed to be, in that moment, present with that client. So when that happens, when we lose our connection to the present moment, our stress hormones spike, our decision-making ability drops, and most importantly, critical attention to detail, which is essential for us lawyers, diminishes significantly.
This is the problem, and I know I had it. Most lawyers spend their days mentally elsewhere. We're either replaying past cases or anxiously planning for future outcomes. I know I used to return to past cases, past motions, past pleadings. Did I do it right? Was there anything I did wrong? Should I have added anything? Why did I lose that motion? What did I argue that was wrong? Constantly questioning myself. And sadly, not from a spirit of becoming better, but from a spirit of self-judgment, of self-criticism. Or I anxiously planned for the future outcome. Not from a sense of outlining my discovery schedule or listing my witnesses and preparing when I was going to meet with them, but worrying, am I going to lose that trial? What happens if I lose that trial? I don't think I'm going to win that trial. What does that mean? What's going to happen? And what did that mental absence do? Well, first it creates stress. But more than that, it creates errors because we're not fully focused on what we're working on. And it creates misconnections with my family, with colleagues, with clients while I'm in a client meeting. I realized that presence is where all effectiveness lies. And these are the three mental traps that we all struggle with. The first is the prison of the past, replaying outcomes, second guessing our decisions, wishing we'd handle things differently. Have you ever done that? I did it literally every single day. But even worse for me was the fear of the future. Constant what if planning, getting anxious about deadlines, worrying about opposing counsel's next move, but worst of all, awfulizing about the results, expecting I was going to lose a case, worried about what the outcome would be and wondering what the impact would be on me and my practice if and when that happened. And the third prison is the multitasking myth. Believing that doing multiple things at once means I'm more productive. But I've learned it actually doesn't mean that. It means the opposite. It reduces our quality and increases errors. So a couple practical solutions. The first is the 45-5 focus method. Work intensely on one task for 45 minutes and then take a brief 5-minute break. And during those 45 minutes you're working, no emails, no calls, no quick peeks. And then repeat that during the day. But block out time to return your emails, return your calls, batch them all together. But when you're working, when you're doing that focused work, don't let yourself be interrupted. Train your staff to not interrupt you. And make sure you're focusing on what you're working with. If you find your mind drifting to the past or present, be aware of that and call yourself back to the present. The second is the power pause practice. In the morning, set your intention for the day. Just take a couple of minutes. What's most important that I get done today? Who needs my best attention? Who will I best serve today? Set your intention. Midday, take a break. Reset and recalibrate. How did you do? Did you get distracted? Did you lose your focus? What are you going to work on in the afternoon? How are you going to get it accomplished? And again, focus. And in the evening, I do a brief review. I think of the three tasks that I got done that day, the three most important tasks that I actually got completed. I think of one lesson I learned that day and one thing I'm grateful for. And setting those pauses, you wonder, why do I do that? What's that mean? It helps you stay connected to the present. And that's what it's all about. Because this is the insight. Every successful motion you've ever written, every case you've ever won, every client you've ever helped, it all happened in the present moment. And that's where your power truly lives. Theme 2 is turning our setbacks into strengths. And this was episode 299 of the Free Lawyer podcast this year. How often did I think I never should have taken this case? Those words haunting me at 3 a.m. We all have that moment. The case that got away, the motion that backfired, the trial we lost, some defeat, some hurdle, some setback. That puts us into a tailspin. And this is the core truth. Most successful lawyers do not avoid setbacks. All good lawyers lose cases or have matters that don't work out well or lose a client. But the most successful lawyers transform those setbacks into growth and into success. See, it's not the setbacks that cause depression and burnout. It's how we handle them. I believe in the saying, setbacks don't define you, they refine you. See, we can grow from our setbacks. We can learn from them. And the trap is that of self-pity. I remember after losing a big case early in my career, I spent weeks replaying every detail, every witness exam, every argument I made, every objection. What did I do wrong? Why did I lose that case? And what did that accomplish? Absolutely nothing. It cost me mental bandwidth. I lost my confidence. I lost precious time. It actually nearly cost me my love for the law because that case upset me so much. That self-pity didn't just feel terrible, but it actively prevented my growth. So here are 3 questions you should ask yourself after a setback. And for me, these 3 questions changed everything. What exactly went wrong and why? What will I do differently next time? And how has this experience made me a better lawyer? Those 3 questions really work. I suggest you write them down and keep them handy when you have a setback. So here are 7 strategies I have for resilience after you suffered a setback. The first is gratitude. After losing, write down 3 things that went right. So for example, your client's response. I lost a terrible case. Last trial I ever had, I lost a case I thought I would never lose. My client was, but Gary, you did a great job. And then she sent me another matter. Or your preparation, or the respect of opposing counsel. So think of 3 things during the case that went right. Second is reframing. Instead of, why did this happen to me? Or, am I really a loser? Or, am I not a very good lawyer? Ask this instead. What can this teach me? What can I learn from this? The third is breaking free from self-pity. I know that losing a case, particularly if you lose one unexpectedly or if it's particularly hard fought, it's easy for me to say, don't let it bother you. But the reality is it's going to, right? It's going to. But give yourself a set amount of time to feel bad. Say 24 hours or at the outside 48 hours to feel bad. Then get back into action. End your self-pity. Give yourself time to feel it and then move on. The fourth is to build client trust. And I follow the 3 R's. I report immediately to client about some negative development in their case. And without any sugarcoating, I report immediately and accurately without hiding anything. I respond with a clear action plan. How are we going to handle this? What's our next step? And then I reassure my client of my commitment to the client. And I find that really works. Clients like the honesty, the transparency, the acceptance of responsibility, hearing a plan, and letting them know I'm really committed to them. 5, taking small steps. Sometimes after a defeat, it's hard to jump into some big project. So don't start with huge steps, but find small wins that you can use to create that momentum back again. Some matter that you can handle that's easy, that's quick, that gets you a win, that you get back on track. 6, having a success squad. It's so important to build a network of colleagues or a mentor or peers to have the right perspective. We all lose cases. We all beat ourselves up about them. But talk to friends and colleagues, vent with them, and they will give you support and encouragement that you deserve. And 7, mindfulness. Take 5 minutes of daily reflection. It will improve your focus. It'll improve your clarity and it'll reduce the stress. This is the key insight from this episode. Your resilience is not just about you. It affects your client's confidence. It sets examples for junior associates, and it builds your reputation. One of my biggest client retention wins came after a significant loss because of how I handled it. And each year, you will become a better lawyer by learning from the setbacks that happened. So before I share the final 2 themes, I want to ask you something. Which of these first 2 lessons hit home for you? Is it the present piece, realizing your mind has been everywhere except where it needs to be? Or is it the setbacks, recognizing you've been stuck in self-pity when you could be learning? Drop a comment below and let me know. I read every single one. And if you're watching this thinking, I need help implementing this in my practice, that's exactly what my complimentary coaching call is for. And the link is in the description, or you can go to GaryMiles.net. Let's talk about building your personal resilience roadmap. Now let's get into the final 2 themes because these can be game changers for this year. Theme 3 is AI as a tool, not a threat. And this was episode 300 with Tim Sawyer.
AI is in most of the workflows that we have now, right? If you're doing autocorrect for spelling, Well, there's an AI component to that, right? So you can apply the same concepts to email. It's doing the same thing over and over again. And now you see there's a lot of different platforms that are trying to correct emails for you as you do it. There's nothing we're doing with our platform that is designed to replace lawyers or paralegals or legal assistants. That's not the point, right? You cannot. There is no AI platform that is 100% accurate. You can get close, but you can't get there.
I learned to practice law in a day when there weren't even computers yet, much less the internet, much less the cloud, much less AI. And I spoke to a lawyer the other day. I said, "What do you think about AI?" I said, I don't know anything about it. I don't get it. I don't understand it. And I think a lot of lawyers might be worried about a learning curve and how long will it take me to get the hang of this. So Faster Outcomes is an amazing AI tool, AI company that develops good, efficient, productive AI tools for lawyers that are confidential and work well. And this is the reality check. The legal profession is one of the very last industries that is ready for a significant efficiency upgrade. And AI is not going away. It's already in many of our workflows: autocorrect, spell check, search. And the question for you isn't whether you use AI, it's how to use it responsibly. And Tim from Faster Outcomes told me AI can compress what took 2 months into 5 days. Medical chronologies, demand letters, review of discovery, intake processes, all are dramatically accelerated. And the average lawyer spends probably 60 to 70% of his time on tasks that can be automated to 90% accuracy. Saves us so much time. And here are the 3 major buckets AI can transform for you: finding new clients, marketing, content creation, SEO, social media from your existing work product, serving your clients, client intake, sometimes can take from hours down to just minutes, communication automation, and case analysis, discovery, review of documents produced, keeping your clients, better client experience, faster response times, and improved outcomes. But there are ethical considerations. Security and compliance are truly non-negotiable. So here's an important warning: never put clients' names, social security numbers, or medical information into open source AI without privacy settings. The solution is to create private encrypted instances for your firm, and Faster Outcomes does that all the time. The AI output requires human review, and that's that last 10% that we put our own particular spin on it. We check to make sure of its accuracy. We correct any mistakes that were made. What are some common AI misconceptions? The first is, I don't have time to learn this. So start small, build your trust, and expand gradually. AI will replace lawyers. That's not true. No AI platform is 100% accurate, and our human oversight and intuition and instinct is essential. It's too complicated. Clearly not true. If you can upload a document and hit generate, you can use most AI tools. And this is the freedom promise. This is about reclaiming time. Getting 200 hours back in a year means time for kayaking, family dinners, or higher value work. You don't want to waste your time on those routine administrative matters. They can be generated for you so fast and so quickly. And Tim shared that after years of 9 to 10 p.m. nights, he was able to take 35 days traveling the country with his family. AI and automation has changed his life. So here's a starting point. Try open source AI on a document without any identifying information. See what it can do from there, build from there. And if you're interested, reach out to a company like Faster Outcomes that creates AI tools for juries. And theme 4, the psychology of persuasion. This was episode 242 with the amazing Sherry Bellis. Truly an incredible trial consultant to litigators. And this was the core insight that I got from her. When the judge tells the jury to disregard something, how does a jury hear that? And the point is, they don't disregard it. The bell has been rung. See, psychology knows things about juries that law school doesn't teach us. And Sherry shared with us the power of story over facts. And this applies not only to litigators, but anyone does negotiations, and really even sharing your stories with your clients and prospective clients. See, what we do is often present dry facts when they should be creating compelling narratives. And the theme should come before everything. I know lawyers whose opening starts with, "Hi, my name is Gary Miles, and this is an opening statement, and I'm proud to represent Jack Jones, who was a driver of the truck involved in this accident. And what I'm saying is not evidence," etc., etc. You've lost the jury. But instead, your opening should start with a compelling story and with a theme. Like, this is a case about putting wealth before health. That grabs the jury's attention. And introducing yourself doesn't. We get mired in the weeds after years on a case. We often can't see the theme and see the story, and that's where Sherry comes in. She's, like I said, an incredible trial consultant. She gives a fresh perspective and often can reveal the best theme to us immediately. And our advocacy bias, we look at things from our own tunnel vision, our own unique space. And that often blinds us to how others from the outside might see our case. Here are some secrets about your opening statement. Never start with your name or your civics lesson. Start with your theme, your story, bang, right out of the gate. And use the present tense to swoop the jury into the moment. It's 6 a.m. in Wisconsin. Snow's starting to come down. Driver John goes to check his truck, etc. Walk them through your client's morning and put them in your client's shoes. And some voir dire mistakes that Sherry pointed out: don't rehabilitate bad jurors. Asking, for example, but you can't be fair, right? Let them just be bad jurors that you could strike. Get jurors talking with open-ended questions to set up a strike for cause. But rehabilitate good jurors with closed-ended questions like, are you willing to listen to both sides? And willing is a powerful word. Almost everyone says yes to willing. Witness preparation essentials. Start by getting their anxieties on the table. Witnesses need to dump their fears first. Walk through every detail of what they can expect in the courtroom. Tell them about what to wear, who's in the room, where do they sit. For fact witnesses, try to have them tell their story without interruption. You'll get gems from them. For your experts, eliminate the jargon. Teach them to explain like they're talking to 19-year-olds. And watch out for the labeling trap. Watch for adjectives slip before nouns. Your big glasses, right? The stop truck, right? Train witnesses to catch these little linguistic tricks. And for those of you who do defense work, you're probably well familiar with the reptile theory. And these are some defenses that Sherry suggested. You know, plaintiffs try to invoke primal anger about safety violations. And the counterargument is the standard is not safest or the best. It's only what's reasonable. The defense argument is safety is one of many important things, not safety is the only priority. Train witnesses to avoid absolutes like always and never, never, and hypotheticals. So there you have it, 4 lessons that transformed how free lawyer listeners practice law in 2025. The first is presence. Your power lives in the present moment. When your mind races to the past or to the future, you lose all effectiveness. The 45-5 method and power pause practice can bring you back. Second, resilience. Setbacks don't define you, they refine you. Ask the 3 questions. Use the 3 R's with clients. Surround yourself with mentors, and remember, your worst defeat can become your greatest asset. Third, AI's liberation. This technology is not a threat, it's a tool for our freedom. Start small, stay secure, and imagine what you would do with 200 extra hours this year. And fourth, psychology wins cases, wins negotiations, persuades others. Lead with your theme, not with facts. Use the present tense to bring juries into the story. And prepare witnesses for the emotional journey, not just the questions. Here's what I want you to take into 2026. And this is the key. You do not have to choose between professional excellence and personal freedom. That's a lie our profession has told us for decades. The attorneys who thrive, who sustain excellence over 30, 40, 50 years, are the ones who master these principles. They are present. They are resilient. They embrace tools that free them. And they understand the psychology of persuasion. That's the free lawyer life, and it's available to you right now. If this episode resonated with you, here's how to stay connected. First, hit that like button and subscribe. I release new episodes every week. I have solo episodes on Monday and guest episodes on Thursday, and they're all focused on helping you practice law with purpose and live life with freedom. Second, share this with a colleague who needs to hear it. Sometimes the right message at the right time makes all the difference. You might be the person who changes their 2026. Third, if you're ready to go deeper, if you're thinking, I need a personalized roadmap for implementing this in my practice, schedule a complimentary coaching call. The link is in the description. We'll talk about where you are, where you want to be, and how to bridge that gap. Remember, the practice of law doesn't have to be a prison. You can be successful and be present. You can win cases and you can have dinner with your family. You can build a thriving practice and you can enjoy your life. The choice is yours. The time is now. I'm Gary Miles. Thank you for making 2025 an incredible year for the free lawyer, and I look forward to enjoying 2026 with you. As always, practice law with purpose and live your life with freedom. Thank you.